And the first order of business is our land acknowledgement. As we gather, we would like to acknowledge on behalf of the Township of Whitewater Region and our community that we are meeting on the traditional territory of the Algonquin people. We thank the Algonquin people and express our respect and support for their rich history, and we are extremely grateful for their many and continued displays of friendship. We also thank all the generations of Indigenous peoples who have taken care of this land for thousands of years. Item number 3, is there any pecuniary interest that councillors would like to disclose? It will be recorded there are none. Item number 4 is our public meeting. And item 4.1 is an application for consent. And I will read this application as a motion. Be it moved, therefore, that the Committee of Adjustment of Township Whitewater Region approve a consent application for the property known as Westmead Concession B, CLF, part of lots 11 and 12, and RP 49R5943 PT, part 1 of RP 49R16945, part 1 of part 2 RP 49R18504, part 4 RP 49R18660, and part 4 subject to the conditions included in this report. Can I have a mover for this motion, please? It has been moved by Councillor Olmsted. And Planner Mackenzie, could you give us the justification for this recommendation, please?
Thank you. So through the chair, the present application was submitted by JP2G Consultants on behalf of the property owners Catherine Tim and Doug LaPointe, identified as an Ontario corporation, which I should have. The purpose of the application is to seek consent to create one new residential lot. The proposed lot has approximately 139.5 meters of frontage on the Ottawa River and approximate area of 1.1 hectares. The subject lands are bordered by residential properties to the east and west, both containing dwellings and accessory structures. The proposed retained lands will be approximately 139.9 hectares in size. Several features of note are associated with the severed parcel, including the presence of floodplain covering approximately 0.55 acres of the subject lands, as well as an existing 20-meter private road right-of-way extending along the northern property border and into the subject lands. Based on the rendering submitted by the applicant, the severed lands appear to be sufficiently sized to accommodate the intended development. The lands were subject to 16 consents previously, which were approved. On November 20th, 2025, the Committee of Adjustment held a previous hearing on this application to receive comments from the applicant, public, and staff relating to the consent application. Consents were received in written form in advance of the hearing, and others were received orally at the hearing. These concerns have been attached to the reports. The number of attachments has increased since the report was drafted. Following the November 20th, 2025 hearing, the applicant moved to withdraw application D-10-287 relating to the creation of a new private road right-of-way intended to serve the lands to the east of the severed parcel of consent application D-10-286. As a result, the lands forming the the lands to the east of the severed lot will continue to use the existing right-of-way, which forms part of the proposed consent today. Within the Planning Act, Section 5312 grants powers to a committee stating a council or the minister in determining whether a provisional consent is to be given shall have regard to the matters under subsection 5124 and has the same powers as the approval authority has under section 5125 With respect to a plan of subdivision and subsections 5126 and 27 and section 51.1 apply with necessary modifications. Section 5124 states that in considering a draft plan of subdivision, regard shall be had, among other matters, to the health, safety, convenience, accessibility for persons with disabilities, and welfare of the present and future inhabitants of the municipality, and to the effect of development of the proposed subdivision, whether the plan conforms to the official plan and adjacent plans of subdivision, if any, the suitability of the land for the purposes for which it is to be subdivided, the number, width, location, and proposed grades and elevations of highways and the adequacy of them, and the highways linking the highways in the proposed subdivision with the established highway system in the vicinity, and the adequacy of them, the dimensions and shapes of the proposed lot, the restrictions or proposed restrictions, if any, on the land proposed to be subdivided or the buildings and structures proposed to be erected, and the restrictions, if any, on adjoining land, conservation of natural resources and flood control, the adequacy of utilities and municipal services. Within the provincial planning statement, part of the vision outlines that more than anything, a prosperous Ontario will see the building of more homes for all Ontarians, and every community will build homes that respond to changing market needs and local demands. It encourages in rural areas building upon rural character and leveraging rural amenities and assets to support healthy, integrated, and viable rural areas. In rural lands, it allows residential development, including lot creation where site conditions are suitable for the provision of appropriate sewage and water services, and promotes development that can be sustained by rural service levels. Section 4.1 of the official plan speaks to natural heritage and does not permit site development on lands identified as significant woodlands unless it has been demonstrated that there will be no negative impacts on the natural features and ecological functions. As part of the application, an environmental impact study has been prepared and demonstrates that no negative impacts would be anticipated from the proposed development. Section 5.2, subsection 9 speaks on natural hazards and encourages development outside of hazardous forest type for wildland fire, however, may permit it if proper risk mitigation methods are implemented. The County of Renfrew official plan designates the property as waterfront and rural. The portion of the lands containing the proposed severed lot is entirely within the waterfront designation. The waterfront designation permits and promotes limited residential uses. The property has been subject to several previous consents and thus must fulfill the requirements of section 14.3, subsection 5 of the official plan, which provides criteria to be considered for an additional consents from an original landholding that has already had 5 or more consents. These criteria include the justification of proposed water and sewage disposal services, why a plan of subdivision is not necessary for proper and orderly development, the need for a hydrogeology study, the need for a lot grading and drainage plan, and the impact of the proposed development on municipal financial resources. JP2G, on behalf of the applicant, has prepared a planning justification report to address the following criteria. So in response to the justification of proposed water and sewage disposal services, they have noted the proposed development meets the criteria listed under the official plan servicing policy, including lot size, water quality and quantity, the density of the surrounding area, and the proposed land use, which is correct for the waterfront designation. Subsection B speaks to why a plan of subdivision is not necessary. In response to this, JP2G listed 8 criteria as to why a plan of subdivision is not justified, which include there's only one new lot being created as a result of the proposed consent. The lot is a large lot of 1.1 hectares, which is located on land suitable for waterfront residential development. No new public roads are required to service the proposed development. The proposed severed lot is considered to be infilling along an existing private road. The proposed lot to be severed completes the development potential of the property, of this section of the property. The proposed severed lot is compatible with the existing waterfront residential land used along Lachlan Lane. The proposed severed lot will not require extensive or complex implementation mechanisms such as an engineered road design or servicing agreements. No adverse impacts on municipal services are anticipated as a result of the approval of the proposed lot. We did, in the original report, we did make note that we were in agreement with the justification provided by JP2G in terms of the policy. However, it has been brought to our attention that there are residents in the area that are not satisfied with the explanation provided in the report. So at this time, I will elaborate a little bit further on the township's analysis of the proposed development in relation to subdivision policies. So the subdivision section of the official plan is, section 14.2 of the official plan speaks to general policies, stating prior to considering the merits of a consent, the approval authority shall be satisfied that a registered plan of subdivision is not necessary for proper and orderly development. A registered plan of subdivision will be the method of dividing land where A, a significant number of new lots would be, or there's a high potential to create and market a significant number of new lots. B, new public roads other than minor public road extensions are proposed. C, extensive investigations regarding such matters as hydrogeology, surface drainage, or environmental impact will be required. Or D, the future development potential of the retained lands or the adjoining lands would be adversely affected by the proposed consent. Additionally, the approval authority shall be satisfied that a consent is in the public interest and that it is not premature in terms of development patterns in the area. And where development proposal abuts an existing provincial, county, or municipal road, the lands are required to provide for the widening of the roadway, may be acquired as either part of the consent or subdivision process. Speaking on the policies of the official plan, in this case for A, the proposed consent is proposing one new lot. I understand the previous development pattern in the area, but we also have to look at the application on its own, and in this case it is one new lot. Additionally, this lot, in planning's opinion, is the only lot with development potential remaining in that area, as it is a vacant lot between two previously developed lots. Therefore, with this consent, we do not believe there is potential to create and market a significant number of new lots in the area. For B, the development is on a private road, so no new public roads or extensions are proposed. For C, extensive investigations. There have been environmental impact studies prepared with the application. However, within our municipality, it is fairly common for consents to involve this kind of study. We see environmental impact studies, hydrogeological assessments, archaeological assessments, aggregate impact assessments, regularly with our consent applications. It's just the nature of the geography of the township. So we typically do not regard those as extensive investigations, just given the nature of our township. So in this case, planning is satisfied. D, we do not anticipate that this would have any future development or impact the future development potential of the adjoining lands. With regards to section 2, the approval authority shall be satisfied that a consent is in the public interest and that is not premature in terms of development patterns in the area. It is not premature in terms of development patterns. As noted, it is between two existing developed residential lots. The public interest, we have to fall back somewhat on the provincial planning statement and other policies in this case, and note that while there has been public backlash, the public interest does extend beyond just the local area, and that the direction of the provincial planning statement is promoting residential intensification and housing across Ontario. So in this case, planning is satisfied with this. And 3, the development proposal doesn't abut an existing highway, county road, or local municipal road. So with those matters considered, as well as the provided justification from JP2G, planning is considering that a plan of subdivision may not be required in this place, and thus is willing to move the consent forward in this case. Moving back to the official plan policies with regards to severances more than 5, Section C speaks to the need for a hydrogeological study. Within Section 2.2, subsection 12 of the official plan, it outlines servicing policies within the township or within the county, and notes 4 criteria to be considered for a hydrogeological study. 1, the proposed severed/retained lot size is less than approximately 1 hectare. In this case, the proposed severance is greater than 1 hectare. The proposed severed/retained lot is within an area of known poor water quality or quantity. The area is not a known area of poor water quality or quantity. The applicant has provided well records for an adjacent property that indicates a sufficient quantity of water available for the severed lands, and therefore sufficient quantity of water should be available as well for the retained lands. It also notes there are no known complaints of poor water quality in the area. 3, the proposed severed/retained lot is within an area serviced by well and septic where the density of surrounding lots, those within 200 meters, is higher than 1 dwelling per hectare. Within 200 meters of the proposed lot, there is 10.91 hectares of land and 10 existing houses/vacant lots, including the lot to be severed. The result is a density of 0.917 houses per hectare. Therefore, the density of the surrounding lots will not be greater than 1 dwelling per hectare. And 4, the proposed use of the lot is industrial or commercial. The proposed use is residential. D speaks to the necessity of a lot grading and drainage plan. In this case, that plan has been deemed necessary and has been conditioned for approval of the consent. And E, the burden on municipal services. The development is fronting onto a private road utilizing private services. Therefore, no additional burden is anticipated to be placed on municipal financial resources. As stated previously, as well with the additional information I spoke on here, the township reviewed the provided justification and was satisfied with the answers, and therefore we deem the consent appropriate to bring forward to the Committee of Adjustment for decision. As the development potential would be considered maximized if the severance were completed, future lot creations on the retained lands will be subject to a plan of subdivision. One thing I will comment on is I believe in multiple emails from residents, they spoke to the fact that 2 consents were completed in 2021 that use the same justification of completing the development potential. In this case, those severances, while they were approved, they were never completed. So those 2 lots do not exist on those lands. And based off the rationale used at that time, it would indicate that there would still be development potential on the lot if it was deemed that there was at that time and those consents were not completed. Therefore, that is why we are providing that justification today of the development potential being completed. So I just wanted to clarify that the 2 consents in 2021 were approved on the basis that it completes development potential. They were not completed, and this new consent is completing the development potential at this time, as there is still development potential from those uncompleted lots. And the severance has lapsed, so they can't be completed retroactively at this point. So that is the justification for using that. I know there was concerns about inconsistent justification within planning, so I just wanted to explain why that justification is coming back in this report if it was stated in the previous report as well. As the required planning justification report has been submitted by the applicant under the policies of official plan section 14.3, the proposed severance can be considered, and that's why we're bringing it forward to the committee for consideration. The official plan outlines waterfront development adjacent to a navigable water body within 300 meters disturbs greater than 1 hectare of land and or lot creation would exceed the 3rd consent permitted under section 14.3 and 14.4. Council shall ensure that archaeological and cultural heritage features are protected. In this case, the applicant has submitted a phase 1 and 2 archaeological assessment, and no archaeological resources are recovered, and no further archaeological concerns were noted. However, the study did make recommendations for the subject property, which will be enforced through the revisal of the development agreement as noted in the condition, or as conditioned of approval, as a condition of approval. Portions of the subject lands are identified as significant woodlands. The applicant has prepared an environmental impact study, which indicates that there will be no negative impacts. The study did make recommendations for the development of the land, which again will be imposed through the revised development agreement. That is a condition of approval. The property is in an area known of is in an area of known karst topography. The chief building official has conducted a karst study and determined that the area is safe for development. The property has areas identified as wildland fire hazard risks. The required assessment was conducted and lands were determined to not be located in an area of higher extreme risk of wildland fire. Under the official plan, no further action is required on this point. Portions of the subject property are located within the floodplain. The report from JP2G identifies a conceptual building envelope which can accommodate a dwelling and the required services entirely outside of the floodplain. A Ontario land surveyor as a condition of consent will be required to come in and confirm that elevation point. The Township of Whitewater Region zoning bylaw, the property is zoned waterfront vicinity and rural in the township zoning bylaw. The proposed lot is contained within the waterfront vicinity zone. The proposed use, lot size, frontage, and setbacks are all met by the proposed development. Additionally, the required 30-meter setback from the high water mark is met by the proposed building envelope. In the report, we have noted some additional concerns brought through the public notice process that we will speak to. Several concerns were brought forward. The primary ones identified by the township were the use of fill in the floodplain on the subject lands and the state of the private road. Additional concerns have noted concerns with the requirement for a plan of subdivision, which is why I spoke on that earlier. In response to the concerns regarding fill in the floodplain, the township previously has relied on the Ministry of Natural Resources as the authority in this case. The Ministry of Natural Resources conducted an on-site inspection and provided a response saying it requires no permit from them and it is outside their purview as they are primarily concerned with shoreline area. Some further concerns have been brought forward, noting official plan and zoning policies regarding fill in the floodplain, which are valid concerns. As such, planning has amended its recommendation to include a condition, which reads as follows, or recommends the amendment of the recommendation to include the following condition: that the owner shall, at their sole cost and expense, remove all unauthorized fill and restore the floodplain lands below the floodway boundary to their original conditions and elevations prior to infilling to the satisfaction of the township and any applicable authority. With the addition of that condition, we believe the floodplain concerns can be mediated in this case through the consent process. Regarding the private road maintenance, concerns were brought forth about the road maintenance not being up to standard. As noted in the development agreement between the township and the owners of the lands, the road is to be maintained to a standard to allow emergency vehicle access. We did reach out to our fire chief, Jonathan McLaren, to inspect the roadway, and he provided the response in attachment number 13 to the report. The response concluded that the road at the time of inspection met the standards set forth in the agreement. However, he did make note that spring tends to be the worst season in terms of private road access. With those comments in mind, the township is willing to go out and re-inspect the road in the spring, once the spring conditions finally come, to confirm that that standard is still being met. Additionally, if residents are concerned that the standard of emergency vehicle access are not being met, as was indicated in some of the emails, they can bring those concerns to the township, and the township can inspect the road and then act on that development agreement with the owner, if necessary. There was also concerns brought forward that the existing roadway does not align with the right-of-way on the property. The applicant provided some additional mapping and information, as well as survey posts on site that indicate that that is not the case, that it's the GIS is misaligned, which is often the case in the GIS. It's not precise, and that the right-of-way is correct on the property and matches the surveyed right-of-way, or the road matches the surveyed right-of-way. There were additional concerns noted about a private road agreement on the roadway. Particularly, one noted was the condition of the private road, and when we also had concerns regarding the lack of legal framework for the maintenance and improvement of the private road over the property. Regarding the maintenance of the road, further to my previous comments, the fire chief has inspected and then noted that it was at an acceptable standard at the time of inspection. However, as noted in his comments, the township can look to re-inspect in future conditions, and the residents can bring those concerns to the township as well under the development agreement. The existing road, and then the other concern was with the road agreement itself, that there's no framework outlining overall the general maintenance and cost responsibilities of the road. Based on our review of previous consent approvals for the 16 residential parcels and information provided by the applicant, it was found that 13 of the 16 lots are subject to a road agreement between the owners and the township. These agreements were the standard practice during the time frame when the lots were created. While there are some minor differences noted between agreements, there is consistency regarding the language used for the private road, being the site is accessed by a private road, which is not maintained by the township and for which the township has no responsibility for maintenance or services. It is understood that the township does not plan to provide any road maintenance or services, and the owner agrees to maintain the access for emergency vehicles and users. These agreements did not stipulate how/when the private road shall be maintained, nor a form of financial contributions from the benefiting property owners. Under the private road standard policy and the official plan policy with regards to private road, in 2019, Council adopted a private road standard policy to guide established standards for the development of new and existing private roads within the township of Whitewater region. All existing 16 lots of previous development were created in advance of the policy, with the latest lots being approved in 2015. Latest lots being approved and completed in 2015. As noted previously, 2 lots were approved in 2021, but they were not completed and lapsed. The private road standard policy aligns with current provisions in the County of Renfrew official plan, which enables lower tier municipalities to develop private road standards. The official plan notes that a private road is one which provides access by means of a registered right-of-way to private property, the use and maintenance of which is the responsibility of the abutting owners. The official plan further outlines that local municipalities are encouraged to develop standards for private road construction and maintenance, which considers the following: minimum width, surface materials, grading standards, turning circle requirements, demonstration for safe egress/ingress. Private roads should ensure appropriate access for emergency services, year-round access if 4-season dwelling exists. Legal tools to achieve these objectives may vary depending on the specific circumstances of a development. The township approved private road standard policy established in section 2 that it is the responsibility of the owner/owners accessing the private road to ensure uninterrupted access, fair use, and cost sharing, to oversee administration and supervision of maintenance works, programs, and related budgets. The municipality will have no responsibility, obligation, or exercise any degree of operational control with respect to maintenance of the affected private road. Private roads are not included as a road classification. Municipality recommends landowners seek professional legal advice when dealing with matters of incorporation, bylaws, insurance, property rights, road ownership, collection of road dues, and remedies for non-payment, etc. The applicants, being 2269805 Ontario Limited, have provided the township with signed agreements/contracts between themselves and individual lot owners that assign responsibility to the lot owners for road maintenance and the payment of associated fees. It is our understanding that the Lachlan Lane Road Committee's concern/challenge is that only the landowners, being on the Ontario Corporation, have the legal authority to enforce and collect fees under these agreements/contracts, and that this authority has not been exercised consistently for all lots. It is also noted that 2 lots developed in the 1980s are not subject to the same private party agreements, further complicating collection efforts. As a result, the road committee is requesting a joint use and maintenance agreement that would authorize the committee to collect funds directly from property owners. However, it is acknowledged that the road committee itself is not a legal entity. Further, in order to ensure the concerns/challenges of lack of payment are met, all the property owners would have to agree to the terms and authorize a joint use and maintenance agreement. Outside of the consent process, nothing would prevent Lachlan Lane Road Committee to pursue a private joint use and maintenance agreement civilly on their own amongst the neighbors. An alternative to the proposed joint use and maintenance agreement for the purposes of responsibility of the road, it would be a common elements condominium corporation, which would tie the property parcels to the condominium corporation and require payment of condo dues and outline road maintenance responsibilities. We will note forever with this alternative as well, it would require retroactive agreement by all property owners to tie their individual lots to the condo corporation. We could not force lot owners who are not interested in joining to pay required fees/dues. We don't have a mechanism to force people to sign these agreements. Staff recommend that the private road agreement for the subject application be consistent with the agreements that were previously required for the existing lots, ensuring consistency with past practices and maintaining alignment with applicable land use policies and the township's local policies respecting private roads. The recommendation also demonstrates appropriate regard for the subject application and the condition precedent related to private road provisions. Staff are satisfied that the existing agreements achieve the intended policy objectives and that imposing additional or materially different road agreement requirements would not be appropriate in the context of this consent application. Thus, planning's position recommendation is to approve consent D-10-286 subject to the conditions in the report. Additionally, we are amending that recommendation to the committee to include 2 additional conditions, one of which I spoke to earlier regarding mediation of fill. The other is regarding access concerns on the private right-of-way of the severed parcel, which speaks that deeded access for any neighboring property owners to the portion of the conveyed lands identified as the private road known municipally as Lachlan Lane be maintained, and that any existing right-of-way and or easement agreements be honored and registered on title for the new lands as needed. With that, that concludes my review of the report, and I'm happy to take any questions.
Thank you very much, Planner Mackenzie. I would ask my assistant here if there's anybody waiting online to be heard.
Yes, there are 2.
Okay.
Mark Monahan is on currently, and then Jeff Dupuis.
Okay, thank you. Okay. You've heard the rationale. I will call upon now the applicant or the agent for the applicant to speak. Chair. Thanks. Please identify yourself.
My name is Brian Whitehead. I'm a planner with JP2G Consultants, representing Catherine Tim and Doug LaPointe on this application for consent. Elsie? First of all, I'd like to thank Mackenzie for a thorough planning summary, which I'll do my best not to repeat. But I did bring these display boards, which will allow me to explain some of the some of the planning policy items that was in his report. Regarding the two conditions that will be added, there was some fill brought in. On the lot, there was like a wavy checkerboard, or not a checkerboard, but a wavy shoreline. There was about a foot of material brought in on a portion of the property. We expected that there could be a condition requiring that to be rectified so that it could be balanced. So there'll be a topographic survey done in conjunction with the boundary survey, because there was a survey required as a condition. And we'll be able to do our best to compare that topographic information with the LiDAR information that we have, and come up with a calculation as to how much fill's been put in and how much needs to be removed. The second item is to ensure that the right-of-way that goes through the lot to be severed is maintained for future property owners. That right-of-way will run with the title anyway, so I don't see a problem there at all. I'll just give me a moment here. It's like Fort Knox here. I was prepared to speak to many of the items that were covered by Mackenzie, so I'm sort of glad that he covered them already. And I'll, as I said, endeavor not to repeat them. One thing I'd like to do. This is a plan showing the entire holding. And it shows where the existing 16 severed lots are located in relation to the retained land. Things I'd like to point out, when I've been working with the clients, well, almost since the beginning, since they've acquired the property. And whenever I work with the client, I look at the property as a whole with the idea of not to adversely affect the long-term development of the potential of the property for a subdivision. And in this case, there's 1.5 kilometers of shoreline undeveloped on the retained land, and almost over a kilometer of shoreline on the Hennessy Bay. The Hennessy Bay side has wetland that's not suitable for waterfront development, but there's approximately about 400 meters of shoreline that is. The floodplain goes back, the lots would have to be set back. It's not as easy to develop but as the current lots, but there is still a lot of development potential on the retained land. The retained land goes right out to the point, which everybody knows is a very popular spot. And there were previous consents on the point, but that point in relation to the retained land would probably be more appropriately developed on a more comprehensive basis as part of a subdivision. So my opinion is that the retained land has great potential for development. It's designated waterfront. It's parts of it mostly waterfront, partly rural. And in no way will this consent have an adverse impact on the future development of the retained land. And also, it's on an existing road, as mentioned by Mackenzie, private road, and it is an infilling. Contrary to what some of the neighbors are thinking, it is an infilling lot between two existing lots. Now, the other thing I'd like to do just quickly is just go through I'd like to go through the land severance history of this property with the committee, just because lots come up about it.
No, not at all. I'm just listening to a stupid meeting.
Okay. The first three lots that were severed from this holding included what's now the Sherman lot at this point, and two lots here, the two lots immediately west of the Monahan property and Broussard. They were created back in the 1970s. Doug and Catherine, they built the cottage here. It predated official plans and zoning bylaws. Well, there may have been zoning bylaws back in the day, but it was early on. But your first 3 lots are pretty straightforward. Moving on in time, decades, into the current century, early, the property was owned by Harold Tim, and Harold severed a 3-acre lot here where the Tim LaPointes live now, and a 1-acre lot at this location for Ed Desjardins, who's also a relative of Harold Tim. That was the 4th and 5th lots, according to and there were the criteria, the current criteria for additional consents was in place at that time. Then we were at 5 lots. Catherine and Doug have 3 acres. They filed 2 applications. So that's 6 and 7. Number 7, or one of these lots is owned by Mr. Dupuis and his wife Katie. I'm not sure the other one, but at any rate, that's 6 and 7. Then, once those lots are created, 3 more. 2 at the furthest on the Hennessy Bay, at the furthest to the west, adjacent to Mr. Desjardins, and the Monahan lot. So now we're up to 7, 10, and then 2 sets of 3. These 3 lots were around 07. These 3 lots down here were around 212, 214, and 215. All of these lots were severed under the consent granting authority of the County of Renfrew. None of those applications were reviewed by this committee. Moving forward, the 2 lots were severed here, but as was mentioned earlier, they were abandoned. And the total number of lots is 16. Okay, just moving to the lot to be severed. The lot to be severed is, as mentioned, it's 1 hectare in size, and that qualifies for an exemption from hydrogeology. Plus, the density of the area is under of the overall density of all the lots in the area within 200 meters is under 1 hectare per lot, 1 septic rather. It's got over 300 meters of shoreline. It's got a building envelope of over half an acre. The building envelope is as large as the neighboring property, some of the other properties above the floodplain. And that's over half an acre above the floodplain is adequate to meet the building requirements for a dwelling and a septic system and comply with the township's side yard, front yard setbacks. It's a beautiful lot, and it's along a beautiful southern exposure, and it's an infilling situation. The right-of-way going through the property will continue. Anybody that has a right-of-way on the existing right-of-way on Lachlan Lane will continue to have that right-of-way crossing this lot to be severed. This sketch doesn't show the previous consent. It was abandoned, which was proposal to have the right-of-way come down here. And there was a previous agreement, an understanding of agreement with the Shermans that in lieu of providing a new access, which Doug LaPointe built, on the understanding of having an agreement and filing the application, paying the fee on the understanding of having an agreement with them, suddenly we find out later there's an objection. So, and in that context, getting back to this, the 2 previous lots that were severed, no objections. The whole 16 lots, never an objection. Ever, that, to our knowledge. So I think the committee needs to ask themselves the question, why all the concern? Like, what's going on? The M&R has come back and said they have no issues with the floodplain. No shoreline alteration involved. Forestry plan came up. Ministry didn't respond. Really, it's no concern. It's not related to it's not a matter before this committee. The county planning department, which reviews all your applications, has given favorable comments from the planning department. The township's building inspector, suitable for a septic system. We've done the karst assessment in conjunction with the building inspector. Fire chief has looked at it. If there's some improvements required to the road in the springtime, we'll deal with that. It's been reviewed, it's been prepared by me, the planning report. I'm a registered professional planner. It's been reviewed by your two professional planning staff on the township. And all of the studies, archaeology, environmental impact study, hydrogeology, all comply. And the conditions, the conditions, the development agreement, the recommendation from me came for a development agreement because of the floodplain, because of the filling that's gone on. I acknowledge that it's needed in this case, and it's not uncommon. So I asked myself, what is the real issue here? Is it the road? We've got the legal opinion from the road committee that first of all, it's clear that this is not a township responsibility. The township, that's clear, and the township shouldn't be involved, in my opinion, in any of the disagreements that exist concerning the road maintenance. But the people that are objecting are thinking that it's my client's responsibility to maintain the road. Whereas we have a legal opinion in item 20 from J.P. Quintil, item 20 in your agenda package, it clearly states when the agreements are registered against the title of the lots to be severed. When the lots are severed, the agreement's entered into my clients because they were the owners of the land, and previous owners, because they were the owners of the lots when they were severed. But the lots, the provisions of the agreement continue to apply to future owners, heirs, and assigns. So the terms of the agreement apply to all the property owners out there. And my client is one of the property owners, and they're 1/16 responsible for the maintenance of that road. And they'll pay their share, knowingly. And so why they're being victimized? I ask myself that. And the only conclusion I can come up with is that it's in their backyard.
It's what?
The lot to be severed is in their backyard. They don't want the lot. The solution for a joint use and maintenance agreement or a condominium corporation, which is ridiculous, but both are unachievable, because if you were to impose a condition on a joint use agreement, the consent would fail, 100%. There's disagreement. There's 2 years to implement the condition. They wait out the 2 years. So a joint use agreement, fine. But get together, sit down, work out an agreement that's mutually benefit outside of the consent, outside of the municipal jurisdiction. This is not the only private road in the township. other private roads that are maintained without the same problems. And really, when did the problems start? There weren't problems when these lots were created and where any of the other lots were created. These lots are 15, there hasn't been a lot created on this property in over 15 years, or 10 years rather, 215. So, and it's the last one. So I'm thinking joint use agreement, okay, but not as a condition. That would just be unfair. It's like saying no. That's all I have to say.
Yes, please, Mr. Baird.
I just wanted to note one thing with regard to the 2021 consents. There was one objection received at that time from Ann and Andrew Bromley, and it spoke to concerns of why a subdivision is not required, hydro capacity, and maintenance of the road.
I stand corrected.
Thank you.
Okay, fair enough. Do I leave these here or just?
Yes, you may. Yes, certainly. Okay. I think what we'll do is have everybody have their chance to speak, and then we can leave questions for council. Therefore, who is next that would like to speak? Is it Mr. Monahan or Mr. Dupuy? Please.
Could I ask Mr. Dupuy to speak? Because I'm going to speak to some of his points.
Oh, that'd be fine, no problem. Mr. Dupuy then, please.
Yes, good morning. Can you hear me? You hear me okay? Yeah?
Yes.
Perfect. Okay. Thank you very much. So my name is Jeff Dupuy. I live on the Point Trail, and I'm here today to oppose this application for consent. I'm opposing it because of how this land has been planned, how it continues to be planned,
Excuse me.
and who pays the price. Yes?
Is really where we can turn this up?
Your voice is not matching. We can hear you, but it's hard to understand you, Jeff.
Okay, so what I'll do is
There.
I will turn my video off then, so it's not confusing to you.
Uh,
Is it good for you?
Okay.
Is that okay? Does that work?
Yes, thank you.
Thank you.
Okay. So I am opposing this because of how this land has been planned, how it continues to be planned, and who pays the price when that pattern is allowed to continue. So there are two core issues at the heart of this decision. The one, there are clear violations of the official plan, including unauthorized fill in the floodplain. And two, there has been a long and deliberate pattern of creating a subdivision by piecemeal severance. Now, this is not theoretical. These issues have already caused permanent damage to the landscape, repeated disruption, and now ongoing legal conflict between residents and the landowner. So council, the decision before you is straightforward. You can approve a 17th lot through severance on lands where the rules have already been broken, or you can draw a line and say that in this township, development follows the rules, not the other way around. So I'm going to start with speaking to the fill in the floodplain because it speaks directly to the planning integrity. We all know that the official plan prohibits development and site alteration in the floodplain. That is not in dispute. What is also not in dispute is that fill has been placed in the floodplain, recently acknowledged today by Mr. Whitehead. At the November 2025 meeting, the applicant's own consultant said, yes, there were alterations made. The township staff asked them not to do it, but they did it anyway. I asked them not to do it, but they did it anyway. And then he explained the mindset behind that behavior. He said that some property owners feel that if it's their land, they can do what they want. So those are clear admissions. Despite that, planning staff are recommending approval first, with the idea that compliance can just be sorted out later. That reverses the planning process and sends the wrong message. that you can develop first and deal with the rules later. And since the last meeting, a new legal letter has been filed confirming that the township has a duty to ensure the floodplain is remediated prior to considering any severance. And it warns that this committee of municipal liability if it fails to do so. Now, I note that planning staff is recommending remediation as a condition of approval, but the legal letter is clear. The land must be remediated before a severance can even be considered. So it's also important to note that this behavior is not an isolated incident. The owner has shown a clear pattern of acting first and dealing with approval later. For example, in 2021, the owner significantly altered the 2 lots on the point before the committee approved those severances. The land was disturbed, residents lived through the disruption, and then the severances lapsed. So that damage was done for nothing. We're also seeing the same thing again with this application. You'll remember at the last meeting, there were 2 severances that were proposed. The first one was for the lot itself, and the second one was for a dedicated access road. The owner had cleared the trees and altered the land for months to build on that road, and the residents lived through the disruption. But then the access road application was withdrawn, making all of that work entirely avoidable. So in both of those cases, the pattern is the same. Build first, ask permission later, and then the residents are left dealing with the mess. So this application is also repeatedly described as only 1 new lot, but that framing is very misleading. This would be the 17th lot created by means of severance on the same holding. So at that point, you're not deciding on just 1 new lot, you're deciding whether subdivision scale development can continue through the consent process. And on that point, the most important evidence comes from the applicant's own consultant. He said at the last meeting, and again today, that he's been involved since the beginning, and that at the beginning of this very process, they considered how the property could be developed in accordance with a plan of subdivision. That is his quote from the last meeting. That admission makes one thing clear, that this was always a multi-lot development concept, implemented piece by piece through severances rather than openly and transparently through a plan of subdivision. He also made it clear last time and this time that this is not the end. Mr. Whitehead said last time that the whole property is 140 hectares, that it's a huge property, that there is lots of room on the retained lands for future development by way of a plan of subdivision. So this is not 1 lot. It is one more step in an ongoing process of future development. The staff report again relies on the idea that this severance closes out development potential. But council has heard that promise before. In 2021, during consideration of earlier severances, Mr. Ivan Burton was very clear about what council was being asked to accept. He told you on the record, and I quote, "This is going to close out the development potential of the property. We are not going to support any further severance applications for this property." And that statement was not made casually. It was offered as the justification for approving those severances at that time, essentially asking council to accept the additional studies and conditions on the understanding that this really would be the end. In plain terms, council at that time was asked to pinch its nose and to pass it, because there would be no next time. And yet, here we are again. Despite those clear statements, this application was allowed to proceed, and it has been brought back to council using the exact same closeout language that was relied upon before. And that raises 2 serious concerns. The first, it is not reasonable to ask council to accept the same assurance twice. 2 different applications, years apart, cannot both close out development potential on the same land. And secondly, it is concerning that this application has advanced this far at all, given how clear the record was in 2021. This file has required extensive staff time, multiple reports, hearings, consultations, and significant review. And all of this has happened at the taxpayer's expense. So when council is told one thing on the public record, and then the township proceeds as though it never happened, it undermines public trust and the credibility of the planning process itself. It also bears noting that in that same 2021 meeting, Mr. Burden acknowledged that there is no hard limit in the official plan on the number of severances, which means these so-called closeout declarations are not grounded in objective policy. They are completely discretionary assurances. Mr. Whitehead confirmed that same thing at the last meeting. So taken together, this makes the repeated closing out development claim impossible to rely on. So councillors, it was not true then, and it's certainly not true now. And as a result, that claim should carry no weight in your decision today, regardless of the map that you're being presented. In closing, the residents here were not told they were buying into a community that would be developed perpetually, in secret, and in fragments, with repeated disruption, open disregard for township rules. I'm saying to you today that transparency is owed to residents, and council has every right to require it through asking what the big picture is for this area. Now, I also want to be clear about roles here. The applicant's consultant is doing their job. They are advocating for their client. But planning staff have a different responsibility. They are expected to provide independent and critical advice that is in the best interests of the township. And in this case, I'm concerned that that hasn't happened. But ultimately, the decision is not theirs, it's yours. Councillors, you are not a rubber stamp for planning staff. You are not required to accept their recommendation, and especially if it doesn't sit right with you. You are required, though, to weigh the evidence before you and make a decision that protects the integrity of the planning process and the people who live with its consequences. So today, I'm asking you for three things. One, deny this application. Two, require remediation of the floodplain. And three, require any future development to proceed through a plan of subdivision, starting right now and including this lot. Lastly, I want to remind you that the majority of lot owners have gone on the record to oppose this application, despite the personal cost of doing so, and that the only party in favor of this application is the applicant themselves. So with that in mind, not long ago, you asked us for our vote, and now we're asking for yours. Thank you.
Thanks very much for the comments. Next, we'll call on Mr. Monahan. If you would like to speak, please.
Yeah, thanks, Mr. Chair. Like Jeff, I live, well, my wife and I have a home at 378, so next to the lot in question. And I believe we bought the lot in 2013, 2014. We built the following year. So really the development of these lots started around that time, other than the three existing lots that were there, plus Kathy and Doug. Mr. Whitehead mentioned, geez, it's strange that there was no objections to these previous applications. Well, because no one was living there. I mean, we built a home. There's been, I believe, 6 other homes built after that. So just to touch on that for a minute, when we built our home and moved in, Kathy and Doug told us that they had some other lots on the other side on La Pointe Trail and Hamish Trail. They were applying for, I guess. They also told us the area next to us, they at that point owned the lot at 408, which is where the Shermans are now. They told us that area there between us is never going to be developed because it's not able to be developed because of the rules with the township. It's in the floodplain, etc. So we assumed it wouldn't be developed, and we were happy about that for sure. But then other homes started to be built, and Kathy and Doug had said to us that, okay, well, we can only apply for 3 of these at a time because we're trying to get around the subdivision rule, and we have to apply for a subdivision unless we do them 3 at a time. So they were attempting to get 3, and I guess another 3 more, which Mr. White had. I don't know if he was involved at that time, but he said he was. So that was our understanding. And we're not from the area. We didn't know the rules at this time. And so away they went. They've now sold all those lots. And then in 2021, this application came up for the 2 lots at the end, which those consents were granted, but they've since lapsed. And I spoke to Mr. Burton at the time because, again, my wife and I were concerned about what that development would mean for the road and ourselves. And again, one of the points he made, and one of the reasons we didn't object, was because he said this is going to close out the development. And end of story. And we had some concerns at that time. So did, I think, the Bromleys, Dejerta, and so on. But we didn't object. We said, okay, look, fair enough. This is going to close it out, and we'll move on. Well, when it was confirmed in 2021, again, it was at a Committee of Adjustment meeting. Ivan Burton was there, and he assured the committee and sold them on the point that this is just 2 more lots. There's no more development potential. And Jeff, as he said, he's noted that already. So what happened, though, unfortunately, was once that consent went through, a lot of action started to take place. And one of the things that happened is Doug bought a used dump truck, and he said he was going to use that to clean up some property. But what started to happen is the dump truck started going by our house and started filling in the floodplain north of 408, which is where the Shermans are now. And when I say filling in, I mean filling in. I mean, this happened over a period of a year. So there were his dump truck going up and down the road. We weren't watching everything that was going on, but we soon realized that, okay, well, he's filling in 6 to 8 feet of this lot that was, I believe, part of those granted severances. So it was a bit of an alarm bell that went off, but we didn't say anything. And people do things with their own property, and it may not be right, but we put up with it. But then suddenly we heard about this new application, and we weren't watching, but I guess the severance has lapsed. And before the application was put in, we suddenly realized that Doug was taking his bulldozer and plowing areas in the area next to our lot, which is in the floodplain as well. And at one point rolled his bulldozer down to the shoreline and dug a huge rut, and sort of became a swamp, and started working in there. And we said, okay, well, what's going on here? And then, of course, I phoned the township. My wife and I also phoned. And we were informed that they were considering a new lot, 1 or 2 more lots, is the way it was told. Mr. Burton said, well, yeah, the other severances have lapsed. And so there's these 2 other lots they're looking at. And he wasn't too forthcoming. There was no application at that point, but he said what the process is, I guess we work with JP2 and they start planning. And Mr. Whitehead, I think, said at the last meeting that this has happened over a year. There's been planners involved. So this was all being contemplated. And we said, well, hold on here. At the last meeting, you sold this to all of us and the residents that this was the end. And he really didn't have an explanation. I said, well, Ivan, what is the end? You're on record here. You had a committee of adjustment. Mr. Olmsted was chairing that meeting, and it was passed that this was the end. You clearly stated there are no more applications to be considered. There is no more development potential for this property. So he said, well, you know, Mark, I guess there is no end. No, isn't that strange? There is no end. The planner, the CAO of the township is saying there's no end. So that was disturbing to myself and my wife because of what was happening. And we suddenly realized that, okay, well, yeah, we went back to look at the notes of that meeting and we said, where's the teeth in this? I mean, the township voted that this was the end, but now Ivan's saying it's not the end. So where is this going, and what's the credibility of having a meeting and a vote on this thing if there's no quid pro quo? So now we sit here in 2026, and we've got a much different situation than in 2021. We have several more residents on the road. Mr. Whitehead talked about the agreements, the road agreements. I've included some attachments. There's a couple of emails there. A couple of things I'll point out. One is the owners of the road have had different clashes with some of the residents. When we moved in, it was clear that they were not on good terms with two of the longstanding residents. And at one point, it came to the point where, okay, well, the road's not being maintained properly. One of the residents was, instead of, helping with the maintenance of the road, it was dumping gravel on the road indeterminately. And it got to the point where, okay, something had to be done. And a few of the residents got together, including myself, and said we should try to form some sort of road committee to deal with this, because it's an unreasonable situation. And we're going back and forth and having disagreements. So we tried to form this road committee, and we've got most of the areas, the residents there complying, but we run into problems. One is that a few years ago, Doug and Kathy decided they were going to move a section of the road up near Tim. The explanation given was the road was in the wrong spot. Well, this went on for, I'm going to say, 2 years. So cutting of trees, this was all done basically by Mr. Lapointe alone. Put a lot of work into this. And then at a certain point, he just blocked off the old section of the road and said no one's to drive on that anymore. There was very little communication. At one point, we had a road committee meeting. He said, well, I've decided not to put any gravel on that road because I've run out of money. So we said, well, that's not really fair. It should be, up to a standard where it can be maintained. So he did end up pinning gravel. Okay. And he made that road, we believe, no issue at this point. But the problem has been communication. And Mr. Whitehead said that he created this new section of road that would be jogging through and creating a new area around the proposed severed lot to 408 to the Shermans. And unfortunately, we've been talking to the Shermans, and the Shermans said we were never communicated about that road. I've included an email from them from 2024, where again, Doug and Kathy decided to place logs over the road where the Shermans had access, and I guess expected them to go around. And the Shermans, if you read the email, it indicates that they want those removed, and they were removed. But this is the kind of relationship that the residents have with the road owner. It's not a great relationship. And some of the issues now, the owners of the road hired a lawyer, Quintal. There's a couple of letters that have been part of the submission. We also hired a lawyer, Tierney Stauffer, to review what we could do about these road agreements. Because the issue is that the owners of the road, Doug and Kathy, signed an agreement with the township. Now, most private road owners don't have an agreement with the township. And I believe what I was told was that there were some new rules that came into effect in 2020 about private roads. Well, these agreements predate, our agreements predate any of that. And in the agreement, and it's in the notes and part of the submissions, it states clearly between the township and the owners of the road, Doug and Kathy, that the municipality has no responsibility to maintain the road. And the owners have to maintain the road to a minimum standard for emergency vehicles. So again, this has been looked at by our lawyer, and he says, yes, they have an obligation to maintain that road to minimum standards. Now, it also says that they have a right to sign a road agreement with each of the lot owners. In fact, they should. They then have the right to charge those lot owners for their share of the maintenance, which we agree with, and we have signed an agreement. Our agreement, which is part of the package, says we agree to pay our share, and the owners of the road agree to give us a bill at the end of the year. So the disagreement now is that who has the obligation to actually do the work? All of the lot owners, save for a couple, agree that we have to pay our share. So now the problem is we have an issue with the section of road that's going to be part of this right away, because part of this application involves Doug and Kathy selling a piece of the roadway, a piece of Lachlan Lane. It's about a 100-meter section or 130-meter section, which would be form part of this lot. And I've asked the question to the planner that's present, Mackenzie, Bassett, to Ivan, anyone who would listen, why is the road included in the severed parcel? No one can tell me. No one. So I'm confused. Now, either someone's playing dumb or I don't get it, but why would you sell a piece of the road and break up the road and have a new lot owner, a future lot owner, be responsible, I guess, then for the maintenance of that road? So that part of the road, we've been informed by our snow removal, Robert Wright on Rapid Road, that he's not going to plow that section anymore because it's not suitable for plowing in the winter. There's no gravel on it, simply a dirt road. And I think there's a picture of it. So we now have a problem. I've sent an email to Doug and Kathy saying we need that road brought up to a minimum standard. And unless it's not brought up, we're not going to be able to clear the snow. Now, I know you had the fire chief go up there and have a look at it, but I would argue that not being able to plow the road would be a problem for people to get in and out of the property. So look, we want to solve this problem, but we're being hindered by the fact we have no legal agreement to do anything. So we're just individual lot owners here trying to create access to our properties. And right now, the only entity that has the ability to do anything is the township, because you're being asked to vote for a consent application. That's why the lawyer recommended that you ask the owners to enter into an agreement with the lot owners, the owners of the road and the lot owners, to solve some of these issues, because it's only going to get worse if we have more people coming onto the road. So that's the issue about the road. It's not unsolvable, but it's an unusual situation. One, because the owners did sign an agreement with the township, unlike most private roads. And there's some glaring issues that are unresolved in that agreement. So that's my point on that. The floodplain issue. Well, we all know they've been filling in the floodplain. So again, you can't fill in the floodplain. What I find odd is that, the report was written, the staff report was written and submitted on Monday. Didn't recommend any condition about remediating the floodplain. It suddenly came about this morning. Why? Well, again, I and my wife and I spoke to Ivan last week, and we had received the M&R letter from Noah Lepp at the Ministry of Natural Resources. And the letter clearly stated that the area that was filled in the floodplain was not the purview of M&R. And it said it would not require a permit from us. So we said that to Mr. Burton, and we assumed he would address this in his recommendation. He read again the letter. He didn't acknowledge anything, but he said, okay, well, let me see what this means. So it's strange that on Monday he makes a recommendation. He's saying everything's fine. We had a meeting, so we have to go and get a lawyer to clarify the issue. Like, to me, it's unacceptable. The planning staff should be reviewing these things and acting appropriately, not having us to get a lawyer to force them to make another condition. And what's happened here is there's problems with this application. Mr. Dupuis outlined fairly clearly in his submission issues. They talk about infill. Well, in your official plan, infill is defined as an area between two lots less than 100 meters. This isn't that. Okay. Mr. McKenzie, which I'm very confused about, was saying that the two lots proposed in 2021 stated that they were the last lots and would close out the development. There's no more development potential. He stated today that, okay, no, that's not right. This new lot closes out the development potential. The other two lots are still there and they can be developed, I guess is what he said, but they're not part of the development potential. So I'm confused. The applicants have a history here, as Mr. Dupuis pointed out, of making changes to their property in anticipation of, putting another consent application in. And this is a pattern. They received 16 lots here. And I know 3, I guess they started with. So I guess there's 13 more. These consent applications really have been done by way, instead of doing a planned subdivision. Mr. Whitehead at the last meeting and today has shown us the vision for this area. These lots, as he showed us at the last meeting, were part of the plan right from the start. And they didn't go into a subdivision. They should have. But they skirted around the subdivision rules by doing threesies, twosies, onesie at a time. And now you're being asked to do one more. So one of the things that I read in the official plan is there should be transparency about what your future plans are. Well, the future plan was always to develop this lot eventually, and the future plan now is to develop the other two they had. And Mr. Lapointe in the fall has started cutting down trees on another waterfront property. And one of the residents asked him, well, why are you clearing this waterfront? He said, oh, well, I've decided to make a boat launch. Now, boat launch, He already has a boat launch. I haven't seen Mr. Lapointe out fishing in months. So I guess you can accept my sarcastic, attitude here that he's not building a boat launch. He's clearing the next lot for consent. And the more I look into these issues and the more people I talk to, the township has unfortunately gotten into a situation where I call it the just one more rule. Well, it's just one more. What's the big deal? Well, and today, it's just one more. Mr. Baird said, oh, this has to be considered in the application is just one lot. Well, it's not one lot. It's the 17th lot. This was always the plan, okay? So the just one more rule has been used endlessly to go to your committee using a planner like JP2. We're going to make all the arguments. I mean, I listened to Mackenzie. It's an extensive list. But what it is a cut and paste job from the applicant. Now, as Mr. Dupuis said, JP2, very good. They're great planners. But the planning staff has just taken verbatim what they said, and they have marshaled the resources of the township here. They've got a letter from Doug Schultz, the building inspector, saying that this, there's a building envelope here. I called Doug Schultz and I said, Doug, how can this be? You only got about half an acre of property above the floodplain between the road. He says, Mark, I don't make decisions. I just follow the planning. If the planning folks say this is good, it's good. So he goes, I don't want to say anything. And this is the attitude. People don't want to say anything. So the buck gets passed. And unfortunately, now we're sitting here and someone has to take responsibility. So what I would argue in conclusion here is that the applicants have 16 lots. That's enough. Unfortunately, they don't take no for an answer. At the last meeting, when they said no more, their ticket to mean no, but maybe later. And that's what's happening. And this won't stop. The committee has to at some point say no, enough is enough. And we're asking you to say that today. So I'll pass it back to you, Mr. Chair, but I hope this has been informative and I await your vote.
I've remembered to put my mic on, so thank you very much for your comments. And I know that during your remarks that you did mention staff by name, and I'm just wondering, CEO Burton, did you have any comments?
Yeah, I think I would just add that I would recognize that in 2021, when the committee met with respect to the two applications which have since lapsed, at that time, myself as the planner and manager of community development, I did emphasize that those were the last two two lot creations for residential purposes to be created by severance, by consent application. I did state that, there's no question of it. Recognizing that those two additional lots lapsed, they don't exist. There's no lots there. In conversation with the applicant together with their consultant, there was consideration for, in lieu of those two lots, one lot, which is the lot which is in question today. So just recognizing that there was indication in 2021 that would cease the development potential by severance. And then we are stating that as well, the planners, that again today, that in our view, the development potential for this lot by severance will essentially meet its maximum as part of this one lot. We're not three lots, we're from two down to one. There's not three, it's two down to one. Also recognizing that the policies are what drive these development applications. Staff are not here submitting applications, we're not filing applications. They're being filed by applicants, by property owners, by developers. And our role as planners is to evaluate them against the planning policy. So in this case, the planning policy, and it was spoken to by Mr. Monahan, is our severance policies in the County of Renfrew official plan. It's not our Whitewater region official plan. It's a County of Renfrew official plan. It is applicable for other municipalities as well. There are very few limitations on how many lots you can create by severance. As noted by our planner, together with the applicant's consultant, all of the lots prior to today's lot were created under the County of Renfrew's approval authority. I mean, the local council here would have recommended approval or refusal, but ultimately the approval authority was the County of Renfrew. So the county policies as they sit today, there are no limitations. I mean, you need to justify that a plan of subdivision is not required for orderly development and the like, as our planner has spoken to today. But the consent policies, there's no binding agreement or stipulation that would limit the proponents from applying for another consent in the future. Again, the staff's position at this point in time is, our view is that we've met our maximum, and my understanding is the applicants understand that as well, together with the consultant. So that's number one. With respect to the previous consents. So there was a question as to why the lot is the size. Why does the lot include the road? And I mean, we could certainly ask the applicant or their consultant to speak to this. I did speak to them about this prior to the preparation of the report. Was the intent here is to get the size. They want to get to 1 hectare. 1 hectare in size is what allows them to sort of be in that threshold of a hydrogeological assessment. So the intent, and when I spoke to Mr. Whitehead, was the 1 hectare, and he might add other emphasis on the size. Lastly, the recommendation with respect to the fill. Yeah, certainly the report that went out on Monday did not include a recommendation to have some remediation with respect to the fill, but I'm happy to say that subject to further information, staff are recommending that we remediate the site to remove the fill. So certainly that's the approach that we're taking. That's the recommendation from staff as well. So that's all I have to add, Chair Trim. Thanks.
Thank you. Oh my God. Is there anyone else from the gallery that would like to make a comment? Hearing none. All right. Council.
Councillor? Mr. Trim?
Yes?
I wouldn't mind making a comment if possible.
Okay, because you didn't show up. Thanks for alerting me. Yes, go ahead, Mr.
Okay,
Dupuy.
okay. Thank you. Okay, so I want to speak to one of, I believe I've already addressed Mr. Burton's first point about the completing the development potential. I mean, the fact is we can really not take that as credible at all. It's for the reasons I outlined in my statement. But the second part is actually pretty telling to me in relation to the lot size. So I had questioned why does this proposed lot include a portion of Laughlin Lane? It just doesn't seem to make sense, because you're going to inject further chaos into the road, potentially by fragmenting the ownership of it. The official plan is also pretty clear that when possible, ownership of a private road should be maintained to one owner and not fragmented. So to me, I wondered why the justification here. And Mr. Burton couldn't have been more clear. It was to get the lot size threshold in order to evade a hydrogeological study. Okay, so I want to point something out. The township's conclusion that a hydrogeological study is not required is inconsistent with its own prior decisions for this property, and it's not supported by a clear planning rationale. For instance, in 2021, under those previous applications, a revised hydrogeological assessment and nitrate impact study were required due to the cumulative severance impacts and reliance on private servicing. So although a study existed at that time, it was considered outdated, and an updated assessment was required as a condition of approval, secured through a registered agreement. Now, no new technical evidence has been provided here to justify a different approach now. So the current application also relies on an inflated gross lot area. And this is directly to Mr. Burton's point. You're looking at this incorrectly. You're inflating the lot size by including the road. So that includes lands occupied by Laughlin Lane. When you actually exclude the piece of the road itself, the net developable area of that lot falls below 1 hectare, which triggers the requirement for a hydrogeological study. So this is creative evasion here for the applicant to evade a necessary study that considers the whole area here. And so waiving this requirement without an explanation, and in the absence of change conditions, it represents an inconsistent application of official plan policy and undermines the long-term potable water protection. So I would argue that a study is absolutely necessary. However, I'm just pointing out a flaw. My recommendation remains the same. This application must fail today for the reasons outlined previously. So I just wanted to point out those inconsistencies in the township's own policies. Thank you.
Thank you, Mr. Dupuy. I'm wondering, is there a response from staff? Mr. Baird, go ahead.
Absolutely. In terms of 2021, I wasn't here. I can't speak to the application of a hydrogeological study at that time. In my reading of the County of Renfrew policy under section 2.212F, there's 4 criteria when a hydrogeological evaluation should be undertaken. Proposed severed lot size is less than 1 hectare. Proposed severed lot is within an area of known poor water quality or quantity. The proposed severed and retained lot is within an area serviced by well and septic where the density of surrounding lots is higher than 1 dwelling per hectare. And the proposed use of the lot is industrial or commercial. Under the current OP policies, that is the threshold that is applied for when a hydrogeological study is required, and that is what we applied in this case.
Thank you, Mr. Baird. I'm wondering if the applicant would like to respond, please.
Just to add to Mackenzie's comments, the policy criteria that he just read were the part of a major update to the county's official plan that I don't believe were in place when they certainly were in place for most of the lots, but the 2 on the point, I don't believe they were in place for that either. I think these policies came in around 2022. So, and it's an official plan change as part of the comprehensive review that the county did. There were a lot of changes to the county plan, and these criteria were one of them, and they set up a series of criteria where if lots are 1 hectare or greater, then generally they can be exempt from the requirement of a hydrogeology study. So that's really all. We're just following the plan.
Okay. Thank you. At this point now, I'll ask council if they have any comments.
I'll let you go first since you moved the motion. Oh, sorry, I will concede to Councillor Olmsted.
Councillor Olmsted, please.
Yeah. Well, I must say, I think this is the longest application we've ever had to deal with. I have a multitude of notes here on the file. I agree that I do recall being chair in 2021 on this file, and we did agree, and I do recall that lots, I guess it was 17 and 18 at that time, or 16 and 17, I can't recall. The 2 on the end anyway were to be the last 2 on the development. I am certainly not against development. I am very pro-development, as mostly everybody knows. I want to approve this, but I'm having trouble getting it across the finish line for a number of reasons. And there's a number of reasons that I'm looking at. I've never seen so many objections to one file, and it's mostly considering the road and the road agreements. And I do know that over a number of years, it seems like there's different agreements. Unfortunately, we don't have consistency in the agreements that were made. One question I do have for the planner is, was there ever a requirement to bring the road up to municipal standard?
So there isn't. So under the private road standard for existing private roads, it notes that the only time the road standard applies to existing private roads is when 50% of the land use associated with the road is for the new purpose, in this case residential. In this case, the lot is well over 300 acres. We haven't approached that threshold yet under the standards of that private road policy, the private road standard. So at this point, within the framework of that policy, there isn't a mechanism for us to enforce that it be brought to that standard.
Okay, thank you. If I may, I do have a number of points. I'll just keep going.
Oh, just keep going, please.
Yeah. So, of course, another major question I'm sure we all have on our minds is, why is part of the road included in the severance? And I believe that's answered in that I believe it's probably to upsize the lot to probably avoid a couple of studies. To me, that's very problematic for a lot. I think it's number 408, the one in the end. In the billboard that we're looking at here is not consistent with what we're seeing in our files with respect to the yellow lines that we're seeing where the road is. And I think that was due to the consent that was granted in 2021, where the road pretty much goes down, I think it's La Pointe Trail or La Pointe Road, and then comes across over to where lot, could we bring that up on the screen there, please? To lot 408.
You should scroll down, Julie, to the second schedule, I think.
It's page 16 of 89, it says. Yes, that's it, yeah. So if you look on this sketch, okay. So on this sketch, at the top of the sketch, I guess north, I guess this would be pointing north. If you look at the billboard, it's not showing the yellow road in front of lot 408. So I've been down that road before, and it does look like the owners of 408 would have trouble getting to their lot. And I'm not clear whether they're supposed to go through the line, the yellow line at the top heading towards 408, or whether they are to continue to use the existing road, which I do see as problematic if a new lot owner now owns the road. So again, it just is not clear to me and how that would be avoided or maintained. And then we did hear some suggestion that the current maintainer of the road in the winter will not maintain the road because it's no longer part of the road network. It's now owned by the new owner of the lot. So I do find that problematic. I do find there's a concerning pattern of, again, I'm sitting as chair in 2021 when the last two lots were created, which is why I'm sure we're seeing that new yellow line and where the road's supposed to be. And then that has lapsed. So I think it's been abandoned, which it's concerning sitting here as a committee. We're looking at things and it's not being done, and then it's lapsing, and now we're looking at a different potential development, which is fine. We can get through that, but my concern is for the current property owners. So they're looking at a file, they're trying to understand what's going on. Okay, this is what's going to be done, and then it's not being done, and instead we're going to do this instead. So there's not just a clear path of what the future development looks like if we're approving things, they don't get done, and then it lapses. So I assume that if it's lapsed, it means it can't be brought back, I think. I don't know if that's a condition of this severance. But again, I'd like to understand what's the future development of this property. So if we're sitting here now saying it's the last one, it's the infill, it's, whatever we're sitting here saying, well, what about 2 years from now when there is a new council in place? In 2021, it wasn't the same council in place as there is now, not the same committee. You two weren't on the committee. So I'd really like to understand what the future looks like. I do know there's ways around doing a subdivision. I get it. I'm not opposed to it even. But I want to understand what are the future plans. So I think with that, I'm not prepared to approve it. There's three things that I'd really want to see. One is that now there's 16 lot owners, I think, currently. I'd want to see some sort of, I know it's not our responsibility, but I want to see some sort of a road agreement in place that I know you're not going to get 100% completion on it with all the current lot owners, but there needs to be some sort of majority understanding of, okay, this is the road, this is the agreement, this is the maintenance, these are the fees. There needs to be some sort of consistency in the agreements. Two, I'd like to understand the future plans for the property. And again, I'm not even suggesting that you need to go through a subdivision agreement, which can be avoided, but the township and the residents need to understand what does the future look like, because if you don't show them, you're selling the property under false pretenses. So you're saying there's only going to be 8, well then, no, there's another 2. And then there's only going to be 10. Well then, the guys buy lots, and then all of a sudden there's application in to do 3 more. Okay, there's only going to be 15. So in my view, if I'm going to market these lots, and I'm going to be a buyer of the lots, I want to understand what does the future look like? Is somebody going to be building my backyard beside me? When you told me there's nobody's going to build beside me, and now there's going to be somebody building beside me, well, that clearly is not the agreement that we had in place at the time. And 3, I'd like to see that road brought up to municipal standard. So in light of that, I think I'm against the file. Thank you.
Thank you, Councillor Olmsted. Councillor White, do you have a comment?
I certainly do. I know Councillor Olmsted asked that we have road agreements, but this is private land. We can't do that. We can't even ask them what they're going to do with the land in the future. I've tried, and we can't. From the beginning, the minute I heard that the applicant, I just want to explain. When I was on my phone, I took photos of this so I could blow them up. I wasn't not paying attention. But the property owners, for me, the one thing that overrides everything else is that they tried to cheat the system by filling in the property. And now I find out, this is worse for me, that they want to agree to sell the land or include the land for the road in the property. And don't tell me that in future years that the property owner who buys that property isn't going to close it up, because he has every right to, because he owns it. And as far as I know, is the road going to be changed? Is this the road here that we see? Is this going to be approved? Yes.
So the portion of the road outlined in purple is not. It was the previous consent application for new right-of-way. It's been withdrawn. With regards to the right-of-way is registered on title and granted to adjacent lot owners, and it states legally they have a right to access. So if a lot owner buys the new lot and the right-of-way is there, they can't close off that roadway because the adjacent property owners have legal access granted on title of the property, and they could pursue them legally if they tried to cut off their access. So that's, and in the past, we have approved consents that involved portions of private roadways and had the same condition carrying the right-of-way forward. So legally, we're comfortable that the access will be maintained.
Okay. Okay, that's fine, but still, the applicant filled in a floodplain. When I moved to this area, one of the things that happened, I moved here as a reporter, and one of the things that I saw every spring were people who had built in the floodplain, and they're saying, oh, geez, we need help. Well, I'm sorry, but you shouldn't have built in the floodplain, but they had permission from the township. And to do something like that, to disrupt the floodplain by doing it illegally is one thing, but and then now we're asking them to go and take it back out. No, I'm sorry, I don't agree with that. Two wrongs do not make a right. This would be a wrong to go in and remediate it now. This is what the property owner wanted, he got it, because he's got the fill put in there, but that doesn't make it right that he can build in the floodplain. It's still in the floodplain. This is such a mess for me, and I've had discussions with both Mr. Monahan and Mr. Dupuis. They have reached out to me, and I've discussed it, I've taken notes, I've read, I've listened to, when I came here, I had a statement saying, I don't agree. But then Mr. Whitehead got up there and he spoke, and I thought, you know what, he makes sense. He does, maybe I should, but so now there's two things for me. They're selling the road, even though you say it's legal. I have a hard time with that. Where is the common sense in all of this? This is my problem, and I even wrote that in my statement. Where's common sense? The landowners know that the residents who live there now are upset with how that they're doing how they're dealing with all this. I'm sorry. You bought private property, you deal with it. Don't come crying to council that they're being mistreated, because you know what? You bought private property. I wish we could not have private roads. I wish they could all be municipal roads, so that we don't have people complaining that, I'm not being treated properly. You bought private property. I can't say anything more. This is just, it's just beyond belief that this is happening. And yes, it happened many, many years ago, and that's what I've been told before on when I question other severances and other consents. Well, this happened years ago. Well, that doesn't mean it has to keep continuing. And I'm sorry, Mr. Whitehead said it, and I have to agree. There's still 140 acres, I think, to be developed. How do we know they won't be developed 1 by 1, 2 by 2, 3 by 3? So no, I don't think there is any way I can approve of this severance. Thank you.
Okay, thank you very much, Councillor White. If I may, I think we got the message. If I may, a couple of things. I know as chair, I can't tell you the exact applications or when, but during my tenure, we have approved the selling of a right-of-way in severed lots. That is not uncommon, and we've sat around this table and approved it. I just want the planner Baird to confirm that for me.
I can confirm, and if it's okay, one other comment I was hoping to make. So as CAO Burton noted, the official plan, while it does not encourage, it does allow the possibility of more than 5 consents. So from our standpoint, from a policy standpoint, I know questions were made of why we've reviewed this far, why it's even come forward. The policy does provide some leeway forward, and we have an obligation to consider it within that policy. That's why it's been brought forward. So it's not, the official plan does not prevent this kind of development, and under that we have to provide consideration to it. That doesn't mean necessarily have to influence your decision, but that is why it's been brought forward, is because we have to give consideration to it under the policy. That's the only other note I wanted to make in this case.
Okay, thank you, planner. And I do want to make sure everybody understands that people have a right to apply, and the planning department has a right, has a duty to work on that application. So the other thing is, I didn't want staff to go to the bother of counting how many private roads we have, but we have a lot. And I would say on those private roads, we have a similar road maintenance agreement with the the owner of the road. Can you confirm that or explain that, Planner Baird?
I might turn that over to our CAO, as he would have better history than me.
Thank you.
Thanks, Chair Trim. The question is what agreements are in place for other private roads? Is that the question?
The question is it similar? Like we many private roads, and I'm sure that on title, there is an agreement with respect to maintaining the road to a standard that will allow emergency vehicles. I just want to confirm that that's the type of agreement we do have, and it's common.
Yes,
let's say.
so for clarity, since my arrival with the township in 2019, the practice has been to have a road agreement when lots are serviced by private roads. So yes, we've consistently applied this road agreement, and the standard, the road standard was up until 2021 when we adopted the new policy. The minimum standard was to be accessible by emergency vehicles and regular vehicles. That was the standard set. So that is a standard. I mean, the road has to be passable. Since 2021 into 2022, with the adoption of our private road standard policy, we've been implementing it slightly different. We've been requiring that the standard be improved pursuant to that policy. In that policy, there's a schedule that establishes, 4 inches of gravel, the lane's got to be this wide, and so on and so forth. So it might be a bit greater than passable by emergency vehicles. So pre-2021 was the consistent, which is most of our private roads, pre-2021, passable by emergency vehicles, and moving post-2021, 2022, we were into this private road standard. So yeah, it's been consistently applied, yes.
Thank you, CEO. And I have one other, and I'll get back to you.
It's to do with this. It's to do with what he's talking about right now.
I beg your pardon?
It's to do with what he's talking about right now. The private road.
Yeah, this is, yes, I'm sorry. This,
But I want to follow up with Ivan's statement regarding that specific thing, so we don't lose track.
okay, go ahead.
Okay, so if they're private roads before 2019, they do not have to follow under the same standards as of today?
So there was probably a break point in 2021, 2022. 2019 is when I started, so I can't really speak to before that.
Right.
Only the files that I've reviewed. But so in pre-2021, the road agreement that we have on Lackland Lane and the other roads is what is consistently applied. It's a private road agreement. The standard is emergency vehicles. Post 2021, 2022, there's a different requirement. We have a private road standard. It establishes how much gravel you put down on the road. An example of this would be Voyageur Bay Trail, which is being developed post 2021. It has a different standard than accessible by emergency vehicles. The accessibility is the 4 inches of gravel. Now, in the case of Voyageur Bay Trail, they've built it to that minimum standard. We've had it inspected by engineers and staff to sign off on it. So there's 2 different standards, pre-2021, post-2021.
And just to follow up, so if a private road was built years ago and more houses have come onto it, what standard does it go under then? The pre-219 or 221 or current or after 2021?
So the policy does speak to that, and Mackenzie spoke to
okay.
it briefly, so go ahead, Mackenzie.
So within the private road standard, the standard applies predominantly to new private roads for development. However, there is a provision related to development on existing private roads. And that provision is that the standard has to be met if more than 50% of the land use is for the new development purpose, in this case residential. In this case, because the lot is so large, that retroactive standard doesn't apply here.
Okay, you've quite well. And another thing I would like to ask you, Mr. Planner, is your opinion on us entering into an agreement with the owners of the properties, including the owner of the road, for more than that, in this case, maintenance, comprehensive maintenance. And understanding that we would need 100%, first of all, but how would that, should we be, my question, I guess, is, should we be entering into some sort of a civil agreement that we could be liable for, or not even be able to enforce? Thank you.
So we have met with legal counsel for the township to discuss this, and our understanding is any form of agreement on this roadway is going to require all the lot owners to willingly sign on to it. There's not a mechanism through which we can force them. So the reason we didn't include it as a condition in this case is because, in our view, given the history of the road, and we know there's lot owners who already don't pay into it, that it would be unachievable. Additionally, something like a joint use and maintenance agreement should be a civil agreement between private landowners, and it was the position that the township should not be involved with those agreements because that opens us up to civil liability. The one mechanism that was recommended that the township could get involved with was a common elements condominium corporation, which was noted in the report. That would be an agreement the township would be involved in with the established condo board. Why we did not recommend it in this case, because similar to other agreements, there's no mechanism through which we can force all the lot owners to enter into it. And given the road already has people not willing to pay for maintenance or their share, there are concerns that that condition would be unachievable because we couldn't have all lot owners enter into it. So at this point, the township, in consultation with our legal team, was not comfortable enforcing a condition that would be considered unachievable. That being said, that's planning's recommendation. The committee can approve with additional conditions, including the common elements condominium, or deny the application. You are the decision-making authority. So this is just our recommendation based off policy. And the additional public input is something, there are barriers to us considering it as we have to frame it solely within the policy framework. So there are issues that may not be as, planning may not be able to incorporate as well into the discussion. However, committee can consider it in their decision. That's why we have a public comment period. That's why these meetings are public, to allow that opportunity to speak. But with regards to the road agreement, at the time, and CAO Burton can speak further to it if I'm mischaracterizing, but at the discussions with our legal, it was recommended that we do not put ourselves in a position of civil liability by being party to something like a joint use and maintenance agreement. And it was also advised that the mechanism through which we could do it, being the condo corporation, would require all lot owners to come to agreement. And it's been made clear by discussions that that's not happening. So by no means are we opposed to an agreement being come to, but it needs to be handled civilly. It's not something the township, in this case, from our understanding, something the township should be party to for private lands. And that was the understanding we obtained from those meetings. And I don't know if CAO Burton has anything to add to that.
I would only add that it's noted in the report sections from our private road standards policy, and within that policy, which is adopted by our council, it indicates that the municipal's position is that we do not involve ourselves in the private roads. So council in 2019, when the policy was adopted, I correct myself because I was saying 2021, in fact it's 2019, the policy is dated. It does give council's direction that we're not going to involve ourselves within private roads, for clarity. Thanks.
Okay, thank you. Before I conclude with my comments, any? Councillor Olmsted, please.
Yeah, to the planner, or to the planner CAO. So, in your professional opinion, what changes take place if the portion of road is not included in the severance? So, where the yellow line is, we bring the severance to not include the portion of yellow line that goes through the property.
Go ahead. Planner.
Through the chair, so as Mr. Dupuy correctly noted, without that portion of the roadway, the lot would be under 1 hectare. Under the current servicing policies, a hydrogeological study would be required for the land under 1 hectare. And just to speak further on the fact, it was stated we didn't provide an answer for why the roadway is included. It's the applicant's private property. They are allowed to bring the consent forward in whatever form they like, and they do not have to provide the reasoning or the rationale for why they're including that portion of lands. So that is why we can ask them for it after, and I believe in conversations after those inquiries we did, which I haven't spoke to the reasoning why. But if they want to sever a lot in this fashion, that is how we move the application forward. We can't tell them to change the lot configuration unless there's something in the policy that explicitly forbids it, which we would advise them on. And even then, they can still bring the application to committee. Like, we can only advise them if we tell them there's no way it's being passed on these grounds, and an applicant still wants to bring an application forward, that application moves forward. So we can advise them, but ultimately it's their decision what they want to propose on their private land.
Councillor Olmsted.
So can I assume then, because in the discussions that we've had, that portion of road is to continue and be maintained? So if we do not include that, is the lot still have enough property to build on? I assume that we're not going to be anywhere near the road. Like I know we get in whenever they apply for a building permit, a lot of different provisions come into the building permit. They have to be so far from the road, et cetera, and so far from the shore. So if we don't include that, will the lot still be suitable to build on?
It's hard to speak on it because we haven't seen that proposal brought forward, and the consideration was for this proposal. There is, as they've noted, a sufficient building envelope outside of the floodplain, so theoretically it may still be buildable. They would require a hydrogeological study as noted without that roadway portion, but it's hard to say definitively because that's not the proposal that's been brought forward, so we haven't reviewed that proposal.
Thank you. That's all my questions. Thank you.
Thank you. Is there anybody else? Oh, yes, Councillor White, certainly.
Okay, so there's a loophole here then, that they could include the right-of-way as part of the property, but realistically, it's not. Am I correct? Or am I just looking at this wrong?
So the right-of-way is part of the property, but the legal, surveyed, registered right-of-way runs with the property. So that access right remains with the property. So it is part of the property, but the access right is still in place. Like, you can't, you theoretically could down the line, but in this case, and we've conditioned it, they can't remove that access. One, because it'll create a landlocked parcel, which is not permitted. And two, because the right-of-way is registered on title with the property. So in order to remove that from title, that would be a process with the land registry office, and in this case, I don't think it would be approved because it's a used access. So yes, the right-of-way is part of the property, but the access rights and the surveyed right-of-way, which makes up Lachlan Lane, is retained on that property still.
So for me, it is a loophole.
Any other final comments? I certainly, this is,
I will make one further comment to Councillor White's point. There is a policy within the official plan, I believe Mr. Dupuy also noted it, that speaks to where possible, the right-of-way should be maintained in a single ownership. Why we moved forward in this case is because in the past we have done severances, so there is a practice within the township for this. So that's why we were in consideration of that policy. But I will note, while past decisions can inform planning interpretation and previous actions, and we take it into consideration to have a consistent interpretation throughout the township, past decisions to allow that are not precedent setting. The committee considers decision on an application on its own merit. So just because in the past you have made a decision to include the right-of-way as part of a severed parcel, that does not require you in the future to maintain that standard. It is not, yeah, it's not a precedent-setting decision. Each application is its own merit.
I don't know if this is the time to ask or not. Maybe, I don't know. I want to ask for a change to the, what do you call these? The conditions. Do I do that now, or I'm not sure?
I don't think that we can, the planner will explain that, but I don't think we, yeah, go ahead, Planner Baird. Or CEO Burton, you would like to speak?
Under the Planning Act, the committee has the authority to impose additional conditions as they see fit. So we've recommended those additional 2 conditions. That doesn't mean if you approve it now, those conditions are attached. Someone would have to bring a motion to amend the recommendation to include those conditions. And if you want to impose additional conditions, I believe this is how it works. I'll pass on to the acting clerk to confirm. If you want to impose additional conditions as well, that would be a part of that new motion. Similar to if you want to deny, it would have to be a new motion because the motion on the table is for approval at the moment. But I'll let the acting clerk speak in case I've made an error on that.
Yes, thank you.
Yeah, so the motion that's before the committee is the one you read out at the commencement when we started speaking about the agenda item. In that motion, that's correct. In that motion, it speaks to the subject to the conditions outlined in this report. I will highlight that the listed conditions in the report, together with, in addition to, the 2 that we've added as recommended by staff, form part of the conditions as it stands today. I believe what's the number in the highlighted sheet?
2.
9 conditions total.
Total, yes, sorry.
So if a committee member wishes to remove one or add one, you need to amend the motion that's before you. So move a motion to amend, to add or remove a condition, and then that amendment will be debated amongst the members of the committee, decided on, and then we come back to the original motion. Thanks.
Okay, do I have Mr. Dupuy waiting to speak? No, I guess not. Okay, then final comments. It's obvious to me that approve or not approve today, there's still issues with the road that this won't resolve. You know, I'm like Councillor Umstead. We're missing the opportunity of a beautiful family moving into our community. We are all in favor of development. We want that development, of course, to be good development. And I hope that the residents there can, in due time, solve their issues with the road. And so, therefore, I'm wanting to ask if anybody has an amendment to the motion first. Councillor White, well, how would you like to amend the motion?
I would like to remove number 8 and add in, if we can do that, to take out that the owner shall, at their sole cost and expense, remove all unauthorized fill and restore the floodplain lands below the floodway boundary to the original condition, blah, blah, blah. And I want to add in that no remediation be done on this property. It's 2 wrongs don't make a right. So I don't know how to word that, but that would be my recommendation, that there be no remediation, because another ecosystem has already started developing there. And I don't think we should be, taking that away and hoping that the other one will come back. I don't know if that's possible. I'm not a biology or anything, but you've disturbed it once. Let's just let sleeping dogs lie, as they say. That's my if somebody can word that for me properly.
So, and if I clarify me if I'm incorrect, but through you, Councillor White, the motion to amend is to strike out condition 8, period.
yes, and add in that so add in, I guess, number 10, that there be no remediation done to this property.
Yeah, I think the statement is enough that we don't need to add a condition. The complexity here is that the placing of the fill is in contravention to the zoning bylaw. So I'm not certain that the committee has the authority to suggest that we don't comply with the zoning bylaw. So there's a bit of, there's a compliance issue there. And it might be a question that gets raised to all of council as the authority of the zoning bylaw. So recognizing that it is, Councillor White's view that we don't want to disturb the natural habitat again, I would suggest that, and only a suggestion, is that the amendment to the motion is to just strike out number 8 to be debated by the members of the committee.
Okay, thank you. That's fine.
Okay, so,
Remove number 8.
and you move that.
I so move.
Okay,
Striking
and-
out number 8.
And in this committee, we don't need a seconder. So the amendment stands. Now, discussion on the amendment. Hearing none, all those in favor of the amendment, which, if I may, would remove number 8 from the conditions.
Do
Can
we
we
have
just bring
permission to
number 8
speak?
up? For some reason, I'm having trouble finding, oh, it's on there, okay. Gotcha.
Okay.
Counselor, do members have permission to speak?
I'm going to get guidance from the acting clerk, Mr. Burton.
Yeah, so I think it would be practice that we've engaged in the public component of this application. That is, we've heard from the public with respect to the application. We're into motions around the actual motion, amendment motions. I think at this point in time, we would not, it would be common practice that we would not allow the public to speak.
Mr. Dupuy, do you understand that reasoning? Thank you.
I do.
Okay, then I will call for the vote on the amended motion. That is to approve, am I correct? That is to approve this motion, no, to approve eliminating Section 8 from the original motion. All those in favor? Okay.
Are we voting on 4.1, the Committee of Adjustment of Town approve the consent application, or are we just approving the number 8? Yeah,
Yeah,
okay.
just
the amendment.
8.
Yeah, okay.
Okay. All those in favor of the amendment? It's carried. It's carried unanimously. Okay, now, with that, we were ready to move the original motion with 8 not in it. Okay? We have a mover, and so if there's no final discussion, all those in favor? It's lost.
Can we take a 2-minute break?
Oh, yes. Yes. We could take a rest, a little break, 5 minutes. Thank you. Okay, we will call the meeting back to order, and the next item on our agenda is item 4.2. It's an application for consent, and we have a recommendation which I will read as a motion, that the Committee of Adjustment Township Whitewater Region approve 4 consent applications, the creation of 4 new right-of-ways for the land described in this report, subject to the conditions included in this report. A mover for that motion, please. Been moved by Councillor Connie White. And Planner Baird, could you give us the rationale for that motion?
Yes, through you, the chair. So the applications were submitted by JP2G Consultants on behalf of 4 property owners: Catherine McLeese, Lisa Atronki, Kevin and Brenda Grady, and Daniel McLeese and Diane McGee, for right-of-ways across 4 different properties. It's being done as 4 applications because it is one continuous right-of-way, but it is owned by 4 different property owners. So that's why we're looking at 4 applications here today. The purpose behind the application is to seek the creation of these 4 new right-of-ways on each of the respective properties in order to align the existing road accessing these properties with the surveyed right-of-way. There is a surveyed right-of-way on the property already, as noted in the attachments to the report, but it does not align with the road that is ultimately developed there. So the purpose of the applications is to grant these right-of-ways so that they properly align with the existing road. So in the provincial planning statement, section 2.6 speaks to rural lands and notes that development shall be appropriate to the infrastructure which is planned or available and avoid the need for uneconomical expansion of infrastructure. This would align the right-of-way with that existing road so we can avoid the need for additional infrastructure. The concerned parcels are situated within the rural front and waterfront designations, both of which permit residential uses. In the official plan, section 14.3, it states consents may be granted for boundary adjustment, correction of title, leases, easements, rights of way, and other purposes which do not create separate lots. Such consents will be evaluated on their own merit, except as further set out below in the policy. In this case, those provisions for further set out below are not applicable to the application, and thus committee can consider these applications on their own merit. As the right-of-way and the roadway are both existing but do not align, in order for us to ensure adequate access for the residents to their properties, planning is supportive of the proposed consents to align the right-of-ways with the private road and not enforcing any additional infrastructure requirements. The lands are zoned waterfront vicinity and rural, both of which allow residential uses, which is what the lots are being used for currently. Based off the review of the PPS, the official plan, and the zoning bylaw, the consent applications meet these requirements, and thus planning is recommending approval. Oh, and one other note I'll just make quickly is there are 4 separate approvals because these are 4 separate consent applications. You'll note all the conditions for all the approvals are the same across the board. There's no variation, but because it's 4 consent application, that's why you're going to see each consent listed separately in the report to be approved with separate conditions listed, but all the conditions are consistent across the board.
Okay, thank you very much for that. And now, I understand we have Catherine Curry online. Would you like to speak to the application, please?
Thank you, through you, Chair. I'm here for any questions. Planner Bear did a perfect job of explaining it, and I'm just here for any questions.
Thank you very much. Anybody from the gallery wish to speak? Therefore, council, any comments from council? Hearing none. All those in favor of the motion? Oh. Go ahead.
Yeah, sorry, just a question. Was there any opposition or letters come in regarding this file?
We received no written correspondence, although brings me to a good point. Our fire chief, Jonathan McLaren, did make one note, not an objection or anything related to this parcel, but he did note for future development of multiple consents on rural lots for residential purposes, that moving forward, planning within the township should consider conditions relating to dry well provisions, as the fire safety is not always the best there. They don't always have the best water flow. He was satisfied in this case that it doesn't apply, just because these are right-of-ways, not new lots, so they're not fundamentally changing the volume of people there. But I just wanted to bring it forward as something he did note for future consideration for multiple consents in rural areas for new lot creation.
Okay, thank you very much. Anything else?
And sorry, just trying to understand the file a little more clearly. So these are creation of new right-of-ways for the lands, but they're not creating new roads or lanes or anything, correct?
That is correct. So the road is existing on the property, and there was an existing right-of-way on the property, and through whatever process they have found that those two do not align. So the road technically is not granting access to people because the right-of-way is not over it. So the options would be to remediate the road to match the surveyed right-of-way, or to do a new right-of-way that matches the road. In this case, because the road is existing and because the expenditure for new infrastructure would be far more than adjusting the right-of-way, we're bringing it forward as adjusting the right-of-way to match the existing road to ensure everyone has proper legal access.
Great, thank you. And last one. So on the picture that's on the screen, is that is that a lot at the very end beside 10-296? And does it negatively impact that lot or that property?
It does. So it is a lot there. It actually benefits the property, because right now that property would have the right-of-way that exists, which is not in alignment with the road. When we align that right-of-way properly, their access rights will properly apply to the road that accesses their property.
Great, thank you.
Any other concerns? If not, I will call for the vote. All those in favor of this application, it will be recorded as unanimous. Okay, item 4.3. It's an application for a minor variance, and there is a recommendation, which I will read as a motion, that the Committee of Adjustment approve a minor variance application for the property described as Westmeath Concession 9, east of Muskrat Lake, part lots 4 and 5, RP 49R20568, part 1, Curtis Trail, granting relief from section 3.31B to allow for an accessory building, a shed, for a recreational vehicle of approximately 44.60 square meters or 480 square feet. A mover for this motion, please. It has been moved by Councillor Umstead and Planner Mackenzie. Could you give us the rationale for this motion?
Yes, so through the chair, so as noted, the application was submitted by Jordan Glick and Faye Kravitz for the property noted on Curtis Trail. The request is to grant relief from section 3.31B of the comprehensive zoning bylaw. That section outlines that an accessory that section pertains to the temporary use of recreational vehicles on lots. Subsection B speaks to the allowance for an accessory building, including a shed, but does have a size restriction of 15 square meters. The present application is to that size restriction to allow a shed of approximately 44.6 square meters to be used accessory to the recreational vehicle. The subject property is approximately 1.61 hectares in size, is currently vacant. The applicant intends to use a licensed recreational vehicle for this season on the property and would like to use this shed accessory to that for storage, and in the future intends to develop a single detached dwelling on the property. So the provincial planning statement 2.5 encourages development appropriate to rural areas. Section 2.6 outlines that residential development is permitted on rural lands. The county official plan, the property is designated waterfront in the County of Renfrew official plan. The waterfront designation permits residential uses such as single detached dwellings and accessory structures. The Township of Whitewater Region zoning bylaw. The property is zoned waterfront vicinity as per section 3.31. Recreational vehicles are permitted, or the use of one recreational vehicle on vacant land zoned rural, limited service residential, or waterfront vicinity is permitted, provided all other provisions of the zoning bylaw are met. Section 3.31B outlines that the use of a shed as an accessory structure to a recreational vehicle may be permitted as long as it does not exceed 15 square meters. The proposed variance is to allow a shed of approximately 44.6 square meters to bring it into compliance with the zoning bylaw. In considering a minor variance, the Planning Act outlines 4 tests the committee must consider. Test 1 is the general intent of the purpose of the official plan maintained. Yes, the waterfront designation promotes residential uses, including accessory structures. Sheds are permitted under the designation. Is the general intent and purpose of the zoning bylaw maintained? Yes, the general intent is maintained. The proposed use does not interfere with any adjacent uses or contravene the zoning bylaw's broader objectives. The intent is to construct a dwelling on the property in the future, and the use of a trailer and accessory building are permitted on the property. It is noted when they construct a dwelling in the future that the shed at the proposed size would be a permitted accessory use to a dwelling. And the residential use of the property falls within the provisions of the waterfront vicinity zoning. Is the variance minor? In this case, the request is limited in scope, does not result in adverse impacts on adjacent properties, and does not affect the function or character of the surrounding lands. So therefore, we are considering the variance minor. Is the variance desirable for the appropriate development or use of the land, building, or structure? In this case, a shed is an approved residential accessory structure. It can offer additional storage capacity with the use of a trailer for now and in future with construction uses and the dwelling in the future. And will assist in the storage. Well, it will assist in the storage for the future development of the lands. In planning's opinion, the application meets the intent of the 4 tests, and thus we are recommending approval at this time.
Thank you, Planner McKenzie. I understand we have Mr. Jordan Glick online. Sir, if you can hear me, do you wish to make a statement?
Hi there. Just briefly, my family's been coming out to the Ottawa Valley for 30 plus years. I now have 3 kids, ages 9, 12, and 14, and we finally were able to find kind of a dream property that we want to build on and look forward to, being productive members of this community. We just can't do it quick enough. And because we can't do it quick enough, we're asking for a shed just to store some stuff while we make our plans to build. So that's the total scope of the request. I thank you for your time and your indulgence.
Thank you. Anyone from the gallery? No? Then I will remember to ask, Planner, were there any objections to this application?
To my knowledge, we have not received any written objections to this point.
Okay. Then comments for council. Councillor White.
I have to admit, when I was looking at this, and I saw the shed was 3 times bigger than it's supposed to be, I didn't understand how it could be considered a minor variance. However, I did speak with Planner Baird, and he explained to me why. And looking forward to the future, yes, I thought it would be considered. I will consider it a minor variance. Thank you.
Councillor Olmsted? Okay, then, with that, all those in favor of the motion? It'll be recorded unanimous. Okay, and finally, 4.4 is another application for a minor variance. Again, there's a recommendation from planning, and I will read it as a motion that the Committee of Adjustment approve a minor variance application for the property described as Plan 45, part of lots 19 and 20, RP 49R-957548, Rapid Road, granting relief from Section 3.1C and Section 5.2C to allow the construction of accessory building in the front yard and to reduce the minimum front yard setback distance from 7.5 meters, which is 24.6 feet, to 3.04 meters, which is 10 feet, for the purchase of constructing a detached garage. A motion, please, a mover, please. It has been moved by Councillor Olmsted. And Planner Baird, could you give us the rationale for that recommendation?
Yes, through the chair, and bear with me because there's a lot to go through on this one because it's a weird overlapping of policies, but I'll try and explain as clearly as I can. So the present application was submitted by William and Lois Robinson for the described property, granting relief from Section 3.1C and 5.2C to allow a reduced front yard setback and allow the construction of an accessory structure in the front yard. The subject property is approximately 1,600 meters in size and contains a single detached dwelling. I know the GIS shows it as vacant under the current aerial photography. It's from 2024 and it's a bit out of date. There has since been construction of a dwelling on the property. So as per the definitions of the zoning bylaw, in the case of a through lot with equal frontage on both roads, the rear lot line is considered the lot line opposite to the point of access for the property. So just to note, the rear lot line in this case is the portion of the lot fronting on the Raglan Street unopened road allowance to the rear of the property. However, and this is where we get into why the exceptions are for front yard setbacks and front yard provisions. Section 3.38 of the zoning outlines that in the case of through lots that are not corner lots, the front yard provisions of the bylaw shall apply to each yard abutting a street. So in this case, because there are lots on that Raglan Street road allowance and we've considered that it has potential to be developed into a street, we are considering both sides streets at this point, and as such, we are applying this section of the zoning. So the reason we're doing front yard provisions is because as per the zoning, for both sides of the lot which front on the street, we are required to consider both sides of front yard or apply front yard provisions to both sides. So that is the reason why, even though from the use of the property that is defined as the rear lot, for the purpose of this through lot, front yard provisions apply to both lots. In this case as well, there is an unopened road allowance to the left of the lot, which could possibly apply to it being a corner lot. However, for our consideration, because it's not developed and in future could be sold by the township, and there's nothing there currently that would require access from that road allowance in order for development to occur, we are not considering the property a corner lot at this time. So just, there's a lot there, but that's kind of the explanation of why we're doing front yard provisions, even though the structure is located in the defined rear yard of the property. And yeah, hopefully that provides some clarity. I'm happy to answer clarifying questions after the report. Moving on to the provincial planning statement, sections 2.5 and 2.6 outline residential development is permitted on rural lands and emphasizes that rural settlement areas should be the focus of growth and development. Under the official plan, the property is designated rural hamlet. This designation does permit and promote residential use. The property is zoned residential 1, exception 28. The provisions of the zoning allow for a single detached dwelling and accessory structures. The exemption zoning was to permit a minimum lot size of 1,600 square meters for the lot. The lot is considered a through lot as discussed before, which is why we are seeking provisions from the front yard provisions. Specifically, section 3.1C does not allow for the construction of accessory structures in the front yard. And as those front yard provisions technically apply, we do need a variance in this case. And we need because the front yard setback applies, which overrules, or not, doesn't overrule, but because the front yard setback applies rather than the accessory building setback, because the front yard provisions apply in this case, we need to reduce setback from 7.5 meters to approximately 3.05 meters. And that's the application before us. So in considering a minor variance, the committee must ensure the application passes the 4 tests outlined in section 45, subsection 1 of the Planning Act. Test 1 is the general intent and purpose of the official plan maintained. Yes, it's designated rural hamlet. It promotes residential uses, including single detached dwellings and accessory structures. Is the intent and purpose of the zoning bylaw maintained? In this case, we are considering the intent maintained. The proposed use does not interfere with any of the adjacent land uses, nor does it interfere with the zoning bylaw's broader objectives. The lot is already zoned appropriately to recognize the undersized nature of the lot, and also recognizing the undersized nature of the lot does limit the ability to construct an accessory dwelling without contravening setbacks due to the through lot provisions. Ordinarily, our accessory dwelling setbacks are 1.2 meters from side and rear lot lines. In this case, because the property again is situated where it is, we have to consider the front yard rather than the rear and side yard, even though it is in the actual rear yard of the property. In this case, number 3 is the variance minor. The variances are considered minor. The request is limited in scope, does not result in adverse impacts on adjacent properties, and does not affect the function or character of the surrounding area. The development should not have any impact on the road allowance to the rear if/when it is developed, and place no restriction on the development of the lots to the rear of the property. Is the variance desirable for the appropriate development or use of the land, building, or structure? The proposed variants are desirable for appropriate development. The proposed garage is a permitted accessory structure use in a residential zone. Additionally, the proposed location of the garage does permit for easier access to the septic system on the property for in the future. Therefore, based off the provided rationale, it is planning's opinion that the application passes the 4 tests and should be approved.
Thank you, Planner Mackenzie. The applicant is in the gallery. Do you have any comments? None. Have any comments been received with respect to this application?
To the best of my knowledge, we have received none at this time.
I don't believe there's anybody else online at the moment. Therefore, council, any comments? Councillor White.
I just have one, and I spoke with Planner Beard about this yesterday because it totally confused me that in the report, it talks about Jackson's or Raglan Street and Rapid Road, but on the drawing, it talks about Jackson Street and Rapid Road. So I was really confused. Is there any way we could amend the drawing to also include the mention of Raglan Street, just so that it's more clear, or it doesn't really matter?
We can probably just add something on the drawing that notes the location of Raglan Street road allowance in relation to the property. I don't think there's any issue with that. Like, we'd probably just write it on there, but I don't think we would have any issue doing that.
Thank you.
Yes, go ahead.
On my original application, it showed Raglan Street. For some reason, the one that they took the photo of it is not showing it. I noticed that also.
Okay, any other comments?
You should actually say what he said because people didn't hear.
Oh,
I can reiterate it. The applicant noted that in the original drawing provided, Raglan Street was noted, and that in the one used in this case, it is not. So we should have a drawing in our file that shows Raglan Street.
thank you. If there are no other comments, all those in favor of this motion, it will be recorded as unanimous. Thank you. Oh, Okay, and finally, item 5.1, Committee of Adjustment minutes from February 19th, 2026. It is recommended that the Committee of Adjustment approve the February 19, 2026 minutes. Mover, please. Moved by Councillor White. All those in favor? Unanimous? Thank you. And we are adjourned at 12:55.